Welcome to Law Syrup, the show where we talk with special guests about hot topics in Canadian law. This podcast is a co-production with the Ontario Justice Education Network, also known as OJEN. I'm your host, Herman Wong. Let's tap in. Before we begin, please know that this show is not intended to be legal advice or a replacement for a legal representative. Welcome back to Law Syrup. As our second special Summer Law Institute episode, we are featuring a talk by none other than the Honourable Justice Lorne Sossin of the Ontario Court of Appeal. It's a tradition at all Summer Law Institute events that someone comes in to talk about the top 5 cases of the year. And without further ado, here's what Justice Sossin chose.
Thank you. All right, I'm going to try to go a bit mobile. So it's the end of a very intense, informative, hopefully enjoyable 2 days. And so I just wanted to say at the outset, both my congratulations to all those who organized and participated in this rite of passage of late summer, and also to all those who've registered, signed up, engaged, and of course will take much of the engagement of these 2 days into classrooms. And it's with that in mind that I've tried to sketch out this tradition of doing the top 5 cases of the last year to finish the SLI. So you can sit back and relax. The intense portion of the 2 days is over. This is really meant to give you a taste of what's top of mind and occupying our discussions in terms of new jurisprudence, new cases from the Supreme Court dealing with both unsettled questions and unsettling what we thought were settled questions, and a couple that are a little bit of each. So it's going to be the usual smorgasbord of some criminal, constitutional, most involving some aspect of the Charter, but not all. And as in past years, this is the cases, but I'm going to go through each so you don't have to pay too much attention to start. And by the way, I finish, as we do many years, with 5 other cases that we could have selected but didn't. And I say we because I consulted the hive mind of colleagues and got the clerks involved and took everyone's top 5 list. And some cases were literally on everyone's list. Some cases we had to fight over. Some cases were clearly last year's, and in fact were covered last year, but some people thought were so important they should be this year's case as well. Can everyone hear me? I feel like the mic's going a little bit in and out, but I'll stick with it until you tell me that it's bothering you. So I was going to say, as with every year, we, think through, and when I ask colleagues or clerks or others for their view, they of course always want to be very lawyerly, and it's like, well, define what you mean by top. Sometimes they say define what you mean by 5, but when we talk about the top cases, it's not just that the case changed an area of law that affects lots of people. In fact, we often spend a huge amount of time on areas that really will impact a very small number, but with principles that will have an influence over many. So we care about how many people are affected for sure. Media, of course, can drive what a top case is. If it generates a lot of public criticism or involvement, or people are literally protesting in front of the Supreme Court, which happens, those cases are always going to be noteworthy. If there's a legal change, the first case we're going to talk about, for example, the court overruled an earlier decision from 1990, which is when you feel old, because that decision was new when I was in law school. We had to everyone said, you got to get ready for this, it's a whole new area, and of course, one generation later, I'm now deleting it from my mental Rolodex because it's been overturned. So significance of the legal change is important. The compelling nature of the circumstances can sometimes be noteworthy in and of itself and for itself. So the narrative, the story, as I'm sure everyone knows who's tried to discuss a case in a classroom, unless people care about the people involved or the issues involved or see themselves in some sense engaged by it, it's not going to leave very much of a mark. And of course, sometimes it's not the case itself, but what followed the case that becomes significant. For example, one of the cases that's not in the top 5, but made the other 5 that could have been in the top 5, the Working Families case, dealing with the constitutionality of third-party advertising spending that a consortium of unions challenged because it cut into their ability to have a voice in election campaigns, was found to be unconstitutional. That would have been, by the first level Superior Court, and that certainly got attention, got newspapers to report on it, etc. But it was the government's decision the next day to reenact the exact same legislation with the notwithstanding clause. That response became much more noteworthy, and this notion of a red line that used to exist in terms of invoking the notwithstanding clause and what kind of case would need to justify it. All that was shaken up by this move, which then led to a new challenge, this time not under freedom of expression, but under voting rights, which again was successful, went all the way up to the Supreme Court and ultimately upheld by the Supreme Court. So it's now a voting rights case, when it really began as a freedom of expression case, bless you, and somewhere along the way became a notwithstanding clause case. So they take on a life of their own is the moral of the story. By the way, there will be time for questions at the end, but you certainly don't need to wait to the end. So if anything jumps out at you or you'd like to explore as we go along, don't hesitate, jump right in. So I mentioned the very first case involves the overturning of a long-standing 35-year precedent. The case was brought in a sense, in an abstract way. The John Howard Society, as you know, is an NGO that speaks on behalf of, advocates for men who are incarcerated and again for what happens when they're released after they serve their sentences. And in this case, the John Howard Society received public interest standing to bring a freestanding challenge to a new piece of legislation in Saskatchewan, which imposed certain sanctions for prison disciplinary infractions, including segregation for a number of days, including loss of remission credits. This goes again to how long a sentence will practically be, for determinations that someone had breached the prison discipline rules, but importantly treated them as administrative penalties so that you could have them imposed if on a balance of probabilities. So that's the standard of you're 50% plus 1 persuaded that someone engaged in the misconduct, they would get the penalty. And the John Howard Society argued, well, hang on, this is like a penal consequence. This is, in effect, like getting a new prison sentence within a prison sentence. And you ought not, under Section 11D of the Constitution, that says you have a right to be presumed innocent and only to suffer penal consequences after a finding of guilt, which we, on the criminal standard, always take to mean beyond a reasonable doubt. So in effect, their argument, John Howard's argument, was a decision maker could have a reasonable doubt as to whether someone did something and nonetheless impose consequences like segregation and loss of remission, and that violates Section 11D, that presumed innocent until proven guilty provision in the Charter of Rights and Freedoms, and can't be saved under Section 1, because of course there's a reasonable alternative which is impose the criminal standard of proof of beyond a reasonable doubt. The problem and why the lower courts had upheld this provision is a case called Restoule from 1990. And in that case, which dealt with another Section 11 issue, Section 11H, which is the rule against double jeopardy or being sentenced or penalized twice for the same conduct, the court in Restoule had said, well, if prison discipline really were a penal consequence, that would violate Section 11H, because the same conduct could give rise to a criminal charge and a disciplinary charge, but they're not the same. Prison discipline is about keeping order in prison. It's not about breaching societal rules. It's not a true penal consequence. Therefore, it doesn't engage the Charter in this way. And the Chief Justice, writing for the majority and John Howard, said, when you look at the passage of these 35 years, we really look at these issues differently. In 1990, the court brought a very formalistic understanding to what true penal consequences are. And today, we look at things like segregation in a prison, which of course has been the subject of class actions and other charter challenges under cruel and inhuman treatment, etc. And we look at remission, which really does change how long you're incarcerated for. If you take away remission credits, you literally are having someone stay longer in prison. We can't look at those and say those aren't penal consequences anymore. But of course, only the Supreme Court can reverse the Supreme Court. So it took the opportunity to do that and to say that Restoule, which the lower courts had relied on, is no longer good law. Prison discipline is a matter of penal consequence, and as a result, both Section 7 and Section 11D are infringed by this Saskatchewan statute. Yes, question?
I just have a question about the impact that this case may have on civil facilities or for class action proceedings, as well. Why did this John Howard Society or case take on Section 12 as well as these provisions of the Charter?
Yeah, it's interesting, and the question, just for those who might not have heard, is how does this case interact with those class actions and challenges of segregation, for example, and why wasn't Section 12, which was the basis for the unconstitutionality of admin segregation, engaged? One reason might be that the segregation at issue here was modest by those standards. I think it might have been up to 10 days. And the constitutional standard, which is, again, is informed by some international jurisprudence as well, was out of proportion. I forget if it was 2 weeks or what the limit was, that beyond which there couldn't be a justified argument for the continued use of segregation, and in any event it became a constitutional breach. But this provision didn't, in other words, include indefinite or longer periods of segregation. But I think the court's view is a day of segregation is still a day of, in effect, prison within a prison, and would engage those penal consequences. And so it's fair to say the reverse. It's not so much that this case influences those other cases, but those other cases influence how we come to see things like segregation, which again used to be solitary confinement and is still referred to as that in many settings. And this understanding that prison discipline isn't some administrative and therefore kind of less serious kind of experience for someone, that if you're living through it, it has all the same hallmarks of deprivation of liberty and penal effects for those involved. So the protections under the Charter should be the same as well. So clearly the court took the view, it's not that the previous Supreme Court in 1990 got it wrong, but just that our understanding of these issues and of the Charter and its application has evolved, and sometimes that means the court has to evolve with it. There's a dissent, by the way, which says we shouldn't be moving off precedents lightly or without some significant miscarriage of justice or wrongdoing at issue, and Shubli is still good law and should still be followed, and these are different, and it wasn't overly formalistic. So again, almost every case of the 5 has an interesting concurrence or dissenting view too. We don't often spend a lot of time on them in the quick review, but if you're looking at the summaries, sometimes the most interesting issue is seeing how fairly smart people immersed in the record take such a different perspective on the outcome. And certainly there's some frequent flyers. Justice Cote dissents in, I think, 3 out of the 5. We have Justice Jamal both dissenting, concurring, and writing a majority. So we also start to see interesting patterns among the judges as well. But terrific question. Okay. So that is the John Howard Society, and again, anytime the court overrules itself, it doesn't happen all that often. I think it's still a very meaningful moment, especially to see how the court does that. Noteworthy in the Carter decision that's given rise to medical assistance in dying, all that began with the reversal of the Rodriguez decision, again from the early 90s, on the constitutionality of the criminal code provision around assisted suicide. Again, what changed there was not an evolution of law, they said, but in part an evolution of the facts, an evolution of our understanding of autonomy, what it means to lose that ability to decide for yourself when to end your life, etc. So the rationale becomes a really important one for seeing when the court moves off a decision of its own. Any other comments on John Howard? Okay. So, there we go. Moving to the second case, and this is again a series of important decisions from the Supreme Court in the last number of years, really developing this idea in Indigenous and Aboriginal law of the honor of the Crown. And it used to be we talked more about fiduciary obligations that were unique between the Crown and Indigenous peoples, or Section 35 rights to hunt or fish or engaged in practices that date back before contact, or talk about treaties and land ownership and self-government. So all those are important areas in this field. But this in particular, this decision gives a real push to how robust the honor of the Crown is as a notion. And the understanding is because Indigenous peoples lost their own sovereignty and ability to control land, people, and resources, the Crown takes on special obligations after 1763, the Royal Proclamation, through the Constitution Act of 1867, and especially 1982, and Section 35, which protects existing Aboriginal rights, this notion of dealing honorably with Indigenous people. So it comes up in this case, which involves 2 different Indigenous groups, one that had settled their litigation by the time the case reached the Supreme Court, the Robinson Huron and then the Robinson Superior peoples who still had yet to settle. And the issue involved, at the time of ceding control of this land, the promise in response through a treaty was to have a payment of an annuity, which was set originally per individual in the community at this low rate of $1.70, $1.60. The agreement envisioned it going up to $4 per person, but also to be augmented as provided by the value of the resources that were being exploited in the land. So the idea is when the land became more valuable, the annuity would go up. But the ambiguity was, does that mean it would go up to $4 and stay there, because that was the cap that was put in the treaty per person? Or was there a difference? There was a per person annuity that was capped, and then a collective annuity to the chiefs of the Indigenous communities that would go up on a discretionary basis as allowed for by the resources and their value. Ontario took the view it was capped at the $4, and so nothing else was owed. And the Indigenous claimants took the view that it was both not capped and by not being increased was breached in a substantial way over many years, and so a substantial amount was owed to make the community whole. So the court, and again it was a very long trial over a year. Justice Hennessy heard this trial, which is also a model of how courts can engage with evidence from Indigenous communities. She herself participated in community consultations, smudging ceremonies, and writes about all this in her decision. So it's a long decision, but it's one well worth at least skimming. Court of Appeal largely upheld her findings, changed some of the conclusions around the fact that Ontario breached its obligations by not increasing the annuity. And then it reached the Supreme Court, and Justice Jamal, writing for the majority, takes the position that there is this discretion, that the $4 was not, again, going to be paid to individuals. It was a per individual part or component of the overall annuity, but that overall annuity was expected to be augmented over time and wasn't. And that exercise of discretion, the not augmenting, was reviewable by the courts, and that the Crown was under an obligation to exercise its discretion diligently, honorably, liberally, justly, even though it wasn't a specific fiduciary obligation. That would exist, for example, if I give you $1,000 and you're going to manage it on my behalf, you've got a fiduciary obligation to act reasonably to protect and enhance the value of what I've given you. They said it's not quite like that, but the duty to act honorably, the honor of the Crown, that comes from that constitutional context, and that was what Ontario breached in its activities by not revisiting the annuity. And again, that there were specific factors the Crown should have been alive to and wasn't. So interestingly, because one group had settled, one hadn't. Justice Jamal did something a bit unusual at the end of the day when it came to remedy. He said, I'm not prepared to impose a number to say the damages are X millions or hundreds of millions of dollars. I'm not prepared to simply issue a declaration that Ontario has breached its obligations, period. So we tried to do something in the middle, and he said, the fact that you've negotiated Ontario with one of the claimants means you can do this. There is a settlement to be reached, one that's mutually agreeable, and that's the goal, so go off and do that with the other claimants. But I'm not going to wash my hands of this matter. Take a reasonable amount of time, I think it was 6 months, and if you need to, come back, and if we need to impose a number, we will at the end of the day that we think is just and fair, but we want to give you the opportunity to negotiate, and a treaty is always better than a court-imposed settlement on getting a durable, reconciliation-oriented pact between the parties. So he both gave a remedy that left to the government, to the Crown, the obligation to commence negotiations with a view to settlement, but said if one isn't to be had, then the Indigenous claimants can come back and the court will impose one. So that's again something novel in remedies that I think is particularly appropriate in a setting where reconciliation is the ultimate goal, not just getting a fair and just amount that the Crown will pay to the claimant group in this case. So that's Restoule, and again, I meant to check back to see if that time has expired yet and what's come of it, but I haven't done that part, so I will report back. Yes?
Wondering if they consulted any of the provinces that might have gone through the same
So I think there is often in these cases in the evidentiary record some analogous approaches in other jurisdictions. And I didn't notice that in the Supreme Court record here. Again, often it would come up in the trial record. And again, this trial went on for a year plus, so it's a very substantial record. Because it is important not to reinvent a process that might already have worked, and certainly the notion of how to deal with these historic treaties that were often quite exploitative and not always necessarily understood the same by all the parties. Their court made a point to say we treat modern treaties, kind of post-1970s, differently than these historic treaties where we've got to be extra vigilant for kind of injustices. But beyond that, the court took the view that in this modern context, contemporary context, we can leave to the parties to be bringing best practices from other jurisdictions. But clearly there is, for example, in BC, which didn't have these treaties, so has a much higher volume of arrangements, settlements, disputes. Most of the significant Supreme Court case law has in fact been coming from BC. So this is a bit unusual in coming from Ontario, again, in a context where at first glance, holding an annuity to an amount from over 150 years ago can be very hard to defend. Although Ontario took the position that it was always discretionary and it exercised a discretion that was open to it, and that's not reviewable by the court. So Ontario lost at every level on that argument, and that clearly sets a precedent of note for other provinces and territories. Okay, anything else on Restoule? All right, so this one we can deal with a bit more quickly. The Sanis Health really represents one of the increasingly rare times that the Constitution Act of 1867, federalism, comes to the Supreme Court. Used to, of course, pre-charter be the bread and butter of the Supreme Court's constitutional docket. Having taught undergraduates in Ontario, never mind high school students, it's always a hard sell to convey why this matters. In other words, to someone in, Peel, whether your hospital is run, with Ontario paying the bill or Canada paying the bill, most people would say, don't I just care that it's a good hospital and, I'm not treated in the hallway when I get there and the ER has the support. Why would I care if it's coming from Canada or Ontario? Other parts of the country, Alberta, Quebec, notably, they do care passionately, but I find in Ontario, finding a federalism case that's going to really grab people is a bit tough. But this has an unusual underlying premise that is a bit more compelling, which is why I chose it. And of course, because we don't get many federalism cases, the cases we get tend to be quite themselves noteworthy. So here we have a statute that BC passed effectively to create a cause of action to allow it to then sue the companies responsible for opioids and the OxyContin world that we were mired in some years ago, and all of the attendant health costs that flowed from addictions and related health problems. We saw this, by the way, with tobacco as well, where governments went after the tobacco providers for healthcare related costs, which of course were in ultimately the billions. So we have something similar, but the twist is not only did BC create a statutory cause of action to allow BC to go after the opioid manufacturers, but BC fashioned it as a class action provision so that it was bringing an action against those manufacturers and distributors, not only on its own behalf, but on behalf of every provincial and territorial government in Canada. Like all class actions, if another province, say Quebec or Alberta, wants to bring their own or not to bring litigation at all, they can opt out of the class action. But the idea of a class action is that you're covered unless and until you expressly opt out. So the challenge brought by those subject to the coming class action was, well, hang on, BC can't pass legislation that purports to involve all these other governments in lawsuits against us. They would have to bring their own lawsuits. That's how federalism works. Provinces control the civil rights and property that include all civil claims, and this is a civil claim, and so you can't have a national class action by governments in this way. So the court considered that argument, that it violated, again, Section 92, sub 14 of the Constitution Act of 1867, and it rejected that idea because the provision allowing for the class action, it argued, again with a significant dissent by Justice Cote, but the majority argued that it's just purely procedural. It's just a way of bringing an action. And because provinces and territories could opt out, it couldn't be said that somehow they're compelled to be part of that action. If substantively they were somehow going to be touched by litigation that only BC controlled, then they'd have an argument that BC can't tell us what to do or not to do with opioid manufacturers, but that's not what this provision does. For Justice Cote, by the way, she said, well, the fact that they would have to take steps to opt out is in fact making them do something, and BC has no authority to make Quebec do anything, even if it's just to opt out of a class action. So that was her, in essence, her objection. But the majority confirmed that when it's a procedural matter, it doesn't in fact fall under property and civil rights, 9213, but under the administration of justice. How you undertake actions, who's included, who's not. Those are purely procedural. They don't amount to any liability or damages. And if it's purely procedural, it's part of the legitimate scope of a province's jurisdiction over administration of justice. And of course, it's meaningfully connected to BC, and there's a reason why BC is framing it as a class action for efficiency, and so all these cases aren't duplicated, and it's not trying to do mischief, it's trying to simplify a process which again is inherently procedural determination. So that's Sanis Health. It's again a very easy decision to digest, and ultimately is about what the denouement of the opioid crisis is for all the governments who spent tens of millions of dollars and continue to, because it's not like it went away. It simply gave rise to other addictions and other street-related social challenges. So that's an interesting one in terms of the context, and of course restates some interesting principles on why federalism still matters in 2024, and of course in 2025. Okay, we're down to the last two, and arguably each really engages questions that I think are relevant to any high school classroom as much as to any Court of Appeal courtroom. The first, Aaron Campbell, picks up on a question the court dealt with a couple of years ago in Morocco, which is, when do you have a privacy interest in your text? Text like TEXTS. And the issue arises because the standard coming out of that case is you both have to have a subjective interest, you have to believe that what you're texting is private, and that belief has to be objective, be defensible. In other words, you can't say, well, I sent it to my WhatsApp group of 300, but I assume no one would share it with anyone. That's not going to be credible. On the other hand, if you shared it with a very small number of, 8 Instagram followers who are all family members, maybe you could say you had an interest in expectation that it wouldn't be shared beyond those 8. So context drives this inquiry. The facts of Campbell were this, and I know you heard this morning because I was dropping in for a bit on the scourge of fentanyl and some of the proposals to which it gives rise. So this was a enforcement initiative to interrupt some fentanyl and heroin drug dealing. and there was a sting operation on a particular individual who'd been under surveillance. They had warrants, they had everything you'd expect to search. And part of what they found when they searched this individual suspected of being involved in drug dealing was several cell phones. One of the cell phones that they had sequestered was in a lock screen, but when texts come, they light up. So they saw one of the phones light up, and the text didn't make any sense to me, but if you're a trained police officer in drug enforcement, apparently it made clear that there was someone on the other end texting about a drug transaction with fentanyl-laced heroin scheduled for that day. So what the police did, without unlocking the screen, is started responding to those texts, hijacking the phone, in other words, purporting to be the person they had by then arrested, and setting up a deal for that night. And sure enough, the person on the other end of the text exchanges did show up that night, did have drugs with him, was then arrested, charged, and the issue comes up because at trial he said, well, that text exchange was a violation of Section 8. It was a search, in effect, without a warrant, and should be excluded from the trial. And of course, if it were excluded from the trial, there was no other basis to suspect this individual, and the charges would go away. So the initial judge said, well, I don't, by the way, those are the texts. So it was, family, I need $12.50 for this half, though. And apparently $12.50 is the street value of heroin laced with fentanyl in that region, as was known to the police officer. So you have to kind of speak that language, presumably, to get the context. But the original trial judge said, well, this person has no interest in these texts. So there's no Section 8 standing. There's no search here. The texts were sent, and they had access to the phone, and they were investigating, and they did what they were allowed to do. They didn't need a warrant for this. They didn't go to someone else's phone and start breaking in. They just responded to the messages. And further, even if there was a Section 8 issue, which there isn't, it's exigent circumstances, which under the Act entitles police to do things without a warrant that they would otherwise need a warrant for if there's an urgent threat to public safety, to the community, to an individual or officer, etc. Goes to the Court of Appeal. My colleagues, I wasn't on the panel, my colleagues here at the Court of Appeal disagreed with the trial judge on the expectation of privacy. They said, well, this is pretty invasive. You're hijacking someone's cell phone, pretending to be them. Texting about drug deals, in fact, is kind of quintessentially something you wouldn't expect or want to share with the world. So it was clearly a belief that this was a private exchange by the individual involved, which is reasonable objectively when you look at it. So there was a Section 8 issue, and in fact, the Section 8 would have been breached if that were the only question in the eyes of the Court of Appeal. But they accepted the trial judge's finding on exigent circumstances and said there was a deal that was clearly going to go down that night with heroin laced with fentanyl. This was a way of intercepting it. It wasn't practical to go and get a warrant and do all those things while this texting was live in the moment. And so the Court of Appeal upheld the convictions. Goes to the Supreme Court, and they essentially adopt the same logic. They say there is an objectively reasonable entitlement to privacy, to Section 8 rights are triggered by hijacking the text in this way, but exigent circumstances were apparent on the record, did justify a warrantless search, in effect, of the cell phone. And again, a dissenting group of judges took a much stronger view on the exigent circumstances issue and said, no, exigent circumstances are extremely rare, where there's a major threat to public safety, that you're chasing someone who's got a gun and you run into someone's yard. without a warrant, that's exigent circumstances. It's not this kind of scenario. And if we open up these kind of scenarios, what's the point of Section 8 if exigent circumstances can be so broadly construed? So again, a nice distinction in the majority and dissent, with one judge concurring with the majority, but specifically writing because he was bothered by the dissenting judge's view on exigent circumstances. That's Justice Rowe, who concurs but really takes on this dissenting view. So, you know, if you're trying to understand, well, where is the limit on exigent circumstances? Reading through the majority, the concurring, and the dissenting perspectives really gives you a full 360 understanding of a really important issue. Okay, you ready for the last one? Yeah. All right. We're there. Sorry, this I should have gone to this slide earlier. This again is the Supreme Court's reasoning in Campbell, but I've effectively given you the punchline. Again, the exigent circumstances comes from a specific act, the Controlled Drug and Substance Act, Section 11, sub 7 of that. So again, worth taking seriously the statutory context as you're trying to give these words meaning as well. And I assume you're all getting the slide deck, so you don't need to worry about coming back to some of these decisions. So the last case is again a really simple dispute in terms of getting your head around what's at stake, but with many, many ripple effects through the role of courts, the role of legislatures, and the role of the executive in the separation of powers. No pun intended. So power involved someone who'd been convicted of indictable offenses, was a medical technician out east. An anonymous tip outed him as someone who had a criminal record. He was told, you can't keep your job if you have a criminal record, and he soon found out he couldn't get any job as a medical technician in his field with a criminal record. So he applied, as he was entitled to at the time, for clearing his criminal record, a record suspension for certain kinds of offenses. And while he was waiting to hear if it would be successful, Parliament changed the rules, retroactively making him permanently ineligible, and others like him, for a record suspension. So there's another section 11 right, 11H, which is the one that protects you against double jeopardy. You can't be tried a second time for the same offense you've been acquitted for. But it also says if you've been found guilty, you can't be punished twice for that. You get to be punished once for it. And he argued, well, this is punishing me twice now by preventing me from getting my record cleared. And the government effectively conceded that. They said, you know what, that's just right. And in fact, lower courts had already found the provision to be unconstitutional on exactly that basis. So he's kind of got the government dead to rights, as we used to say. That's not what the case is about. The case is about a subsequent piece of litigation he wants to bring to say, not only did you act unconstitutionally, but you cost me all sorts of damages and harm in my chosen field, and I want to sue you for damages for breaching those charter rights. But effectively what he wanted to do was to say that those who worked on the legislation, like public servants, those who are drafters and reviewers of acts and bills, and the parliamentarians themselves violated his rights and should pay. Well, that involves effectively saying the process of legislating can be subject to damages for charter breach. And of course, the legislature itself doesn't have like a petty cash office. They can't go and start paying. So it really means is the executive, is the Crown, is Canada liable for damages for unconstitutional legislation? So there's two questions. One is, can those involved in the process be found liable and government have to pay on their behalf damages? And can Parliament be held liable? And again, the executive have to pay on their behalf for damages. So that's the really simple a powerful question in power. Let me see. And again, the court divides into several different decisions. But the Chief Justice, writing for the majority, says one aspect of this, can you sue for charter damages to unconstitutional legislation, was already decided in effect by a case called Mackin, involving legislation that interfered with judicial independence. And there the court said, yes, you can sue, but only if you can show bad faith or an abusive process or something that was, again, in excess of the authority granted to Parliament. So it was a qualified immunity, yes, but in very narrow circumstances. And, sorry, yes?
So is this similar to kind of Bill 124, where teachers got a remedy from that because it was found unconstitutional, and so they were able to sue? Well, they came with a remedy instead of suing, I guess.
Right, so a little bit different in that they weren't suing for damages under the charter, but effectively the legislation prevented them from accessing a remedy that once it was found to be unconstitutional, they could access. So it relates to a similar kind of idea, except there it was always going to be the executive, Ontario in that case, that would be liable, as opposed to here where the challenging proposition is that effectively you're saying parliamentarians, if they enact unconstitutional legislation, can be liable for civil damages, charter damages, flowing from that. And that, again, the court said, qualified immunity for unconstitutional legislation, only if you can show, again, bad faith, abusive process. But for the people involved, that process of drafting, which was a novel question that hadn't been decided earlier, the majority said, yeah, we can't have important aspects of government life completely insulated from accountability. So this was clearly covered by parliamentary privilege. And again, in most cases, you wouldn't be able to argue damages could flow from it under the charter. But the majority was not prepared to say it's an absolute immunity. There's no accountability whatsoever. Concurring judges, including Justice Jamal, Justice Kassir, agreed with the first proposition that qualified immunity makes sense for legislation, although they would have changed the nature of the qualification. But they would have said absolute immunity when it comes to the process of drafting, that unless you have that parliamentary immunity, it's just sending a clearly dangerous message to those involved, public servants, legislative aides, clerks, etc., that their involvement in the process, if it turns out later to be unconstitutional, can expose them to damages, even if it's the government of Canada that was going to pay the damages ultimately. So really interesting disagreement on principle, on the parliamentary sphere of government being distinct from the courts, from the executive, and the majority's view that the courts cannot be shut out of accountability in any aspect of public life. So a very, again, inclusive, expansive, liberal view of the court's own jurisdiction to bring this particular kind of accountability, damages, to bear on findings of unconstitutionality, and of course let Mr. Power pursue his case against the government as a result.
It's probably clear to everyone else, but the initial legislation that retrospectively applied to him was found unconstitutional.
Correct. That's right. So there was a prior finding, and in fact, it didn't come up in the Supreme Court case because the government of Canada conceded that the legislation was unconstitutional under this Section 11H of the Charter. The government conceded that not just because they could see the writing on the wall, but the writing on the wall had been written by other judges in other cases that had found this to be unconstitutional, particularly the retroactive aspect that really did mean that if you were found guilty and had access to this at the time, it could be taken away, which was a form of double punishment, clearly at odds with Section 11H. So that, again, is a case about something specific with respect to charter damages, but the decision itself has some important things to say about the role of the courts, about accountability in the charter era, about damages in particular as a form of accountability. So really interesting reading, and again, some very different perspectives from judges who often are on the same side. In fact, we're on the same side of many of the other cases we're hearing, but power gave rise to a different constellation of concurring and dissenting judges.
Did you say whether Power won his particular settlement with the government?
So, and that's again an interesting follow-up. It may not even have unfolded yet because, again, litigation moves slowly. But this was about, does he get to the starting line? Can he bring the charter damages claim, or is it barred by an absolute immunity? And he was told, in effect, there's still the qualified immunity from this Mackin case, which has been in place for 20-some years. But there is no absolute liability, absolute immunity, I should say. There can be liability. And of course, it's hard to imagine a stronger case than where the government's conceded the unconstitutionality. So in a sense, he just has to show that he fits within this pre-existing test for damages in a case called Ward and others that are cited in Power. So it's not a slam dunk that he'll fit exactly in that threshold, but he certainly gets to pursue his case. And I'm assuming that's ongoing now if it hasn't been settled. All right, well, at the end, as I promised, here are the other notable cases. I've given you a little teaser on working families already, the voting rights case. There's, again, for those who are interested in the judicial review of regulations as opposed to administrative decisions, all the very many bylaws and regs that are out there, the court had a very protective approach to insulating them from review. And the Our case, the last one, gets rid of that and imposes a much broader reasonableness standard on regulations, a little bit inside the beltway, so that's why it didn't make the top 5, but a big change to the jurisprudence of administrative law. Yes?
Anyway, the Artie Fearing case, I'm not understanding, is that just re-solidifying Artie Fearing with a slight twist on any text? Because I thought that awareness and established in Fearing.
So again, the court's really trying to double down on there not being a rule with respect to texts generally. Rather, they're saying texts can be the subject of reasonable expectation of privacy. It depends again on context. So when I get texts from LensCrafters telling me there's a 50% off sale, always curious, how did they get my phone number and why am I getting, I thought, I have a good spam filter on email, but clearly there's no expectation of privacy from LensCrafters sending me that text. If I'm texting with all of my students in a class about whether we're going to make the field trip tomorrow, again, you're sending it to 25 or 30 people. It's a classroom setting. It's hard to argue you expected a lot of privacy in the content of what you sent. Your text to a particular student who had asked to meet after class on whether you think that's appropriate, that starts to look more like an individual context, and certainly to friends, to family. So they want to underscore for purposes of Section 8 an expectation of privacy that context and fact-specific dynamics will drive that.
Is it both parties, or is it just the one? Because the person who set his phone to have it visible when they come up, I could say it could be on a table in a restaurant. You have no expectation of privacy.
That's right.
So is it that the person who sent it should feel that privacy is there?
And it's typically, because this arises in the particular context of a criminal case, it's that person who's trying to keep the evidence out. So the person who's saying there's a Section 8 breach has to say, I had a reasonable expectation of privacy. We had another case just in the Court of Appeal, so it's not here in the top 5 from the Supreme Court, but raised the really interesting issue of someone accused of sexual interference with a child, their niece. And there were a series of text messages that their child, who was 9, eventually showed to their parents, who eventually brought it to the police. And the uncle said, well, you're misinterpreting it. We had a little game. We had our own little words. But I was just sending it to her, and I have a reasonable expectation of privacy that this wouldn't then be given to the police, used against me. The court was, of course, having none of that and said there is no objectively reasonable privacy interest, even though subjectively I totally get why you thought this wouldn't be shared. But when you send a message to a 9-year-old, the idea that it wasn't reasonable for her to share it with parents or parents to share it with authorities couldn't be sustained. So that's that sense of context. It's in the eyes of the person who's trying to exclude it, person caught up in the criminal proceeding. But of course, the context of who the receiver and the sender were can be relevant. It's not just a myopic look at only the one person to a conversation. And of course, fascinating area that's not going away, given all the complexities of tech and beyond texting, all the ways we have of messaging and communicating with one another in all sorts of novel and evolving settings.
So if you had an investigator who was really big on this privacy, he wants to uphold privacy, he'd be scrolling, if he has access to your phone, he'd be scrolling through, he goes, that one I can read, can't read this one, and he'd be picking and choosing as he goes through, depending on the content of the message.
Right, and again, normally, the remedy is, if you're worried about how kind of incoherent or chaotic it sounds like to parse messages like that, is go get a warrant for the whole contents of the phone, and then you can look at everything and just take what might be relevant. So these cases tend to come about where there wasn't a warrant, and again, either the argument was a variation of exigent circumstance, or a variation of, well, no one could have viewed that as a reasonable expectation of privacy. But you're right that if the police always take a risk, and in fact, it was relevant to the police that they didn't unlock the phone, right? They used the texting that you can do with a locked phone. If they had, forced someone to look at the screen to use Face ID to unlock it, those are different elements of invasiveness and of Section 8 violations. But the way the Court of Appeal framed it is the police hijacked this person's phone. That is pretty invasive and should have been seen that way by the trial judge. So again, not lost in the shuffle is the trial judge didn't see a reasonable expectation of privacy, and the Court of Appeal said, you got that wrong. There is one in these kinds of texts, and certainly when you are hijacking them, it's the most invasive form. You're impersonating another individual.
So it would fall under entrapment in a sense, would it?
Yeah, I mean, it's not entrapment in the sense that
if there's the police that actually sent the text.
Yes.
Right? That would have been a case.
Exactly. If the police hadn't just intervened in an ongoing conversation about a drug deal, but in fact got the number of an associate, texted them and said, hey, how about you bring over some $12.50, then that starts to look more and more like entrapment.
Now, what if they got the owner of that phone to send that text?
Right, and again, if you're compelling someone to do something they don't want to do, you're into a whole other set of constitutional puzzles. Okay, well, I'm at time, but I'm going to hang out for a few minutes. So if anyone wants to continue the conversation or just come up and say hi, please do. Otherwise, I'm giving a mic back to Bryn with my thanks again for being able to participate here and for your attention for the top 5.
Thank you for tapping into this episode of Law Syrup. Law Syrup is produced by me, Herman Wong, and the Ontario Justice Education Network. For more information and for accompanying resources, check out ojen.ca and our show notes. See you next time.